In this video, we will guide you through the process of applying for probate of a will. Probate is the legal process of administering someone's estate after they pass away. Whether you are an executor or a beneficiary, understanding the probate process is crucial. Follow these step-by-step instructions to navigate through the probate process smoothly. We will cover everything from gathering necessary documents to administering the estate. Don't worry if you're new to this, we've got you covered. Welcome to our video on how to apply for probate of a will, a step-by-step guide. Losing a loved one is never easy, and dealing with the legalities of their estate can be overwhelming. But don't worry, we're here to help you through the probate process. Let's get started. Understanding probate. Before we begin, let's first understand the concept of probate. Probate is the legal process of validating a will and distributing the deceased person's assets according to their wishes. It ensures that the person's final affairs are properly handled. Step 1. Gather all necessary documents. To begin the probate process, you must gather all the necessary documents. This includes the original will, death certificate, identification documents, and any other relevant legal papers. Step 2. Identify the executor. The executor is responsible for carrying out the wishes stated in the will. In this step, you need to identify the executor named in the will. The executor is usually a close family member, friend, or attorney. Step 3. Determine the probate jurisdiction. Probate jurisdiction determines which court will handle the probate process. Depending on the location and size of the estate, you may need to select the correct probate jurisdiction. Step 4. Complete the probate application. Now it's time to complete the probate application. This involves filling out the necessary forms and providing detailed information about the deceased person, their assets, and their beneficiaries. Step 5. Prepare the supporting documents. In this step, you need to gather and prepare supporting documents such as bank statements, property deeds, and any other relevant paperwork. These documents help prove the value of the estate. Step 6. Lodge the application and pay the probate fee. Once everything is ready, you need to lodge the probate application with the appropriate court. There may be a probate fee involved which needs to be paid at this stage. Step 7. Publish notice of intention to apply. To ensure transparency, you may need to publish a notice of intention to apply for probate. This notice allows interested parties to raise any concerns or challenges to the probate process. Step 8. Attend a probate hearing, if required. In some cases, a probate hearing may be required. The court will review the application during this hearing and ensure all legal requirements are met. It may involve answering any questions asked by the court. Step 9. Obtain the grant of probate. Once the court is satisfied with the application, they will grant probate. This legal document confirms that the executor has the authority to administer the estate and distribute the assets. Step 10. Administer the estate. Congratulations! You have obtained the grant of probate. Now it's time to administer the estate. This involves paying debts, managing assets, and distributing inheritance according to the wishes stated in the will. Conclusion. And there you have it. A step-by-step guide on how to apply for probate of a will. Remember, the probate process can vary depending on various factors, so it's always advisable to seek legal advice if needed. FAQs, frequently asked questions. What happens if there is no will? If the deceased person did not leave a will, the probate process may involve applying for letters of administration rather than probate. The assets will be distributed according to the laws of intestacy. Can I apply for probate without a lawyer? Seeking legal advice is often recommended to ensure you fulfill all legal requirements accurately. How long does the probate process take? The duration of the probate process can vary depending on factors such as the complexity of the estate, any disputes or contests, and the efficiency of the court system. On average, probate can take anywhere from a few months to a year or longer. What happens if someone contests the will? If someone contests the validity of the will or challenges the appointment of the executor, it may prolong the probate process. The court will need to resolve the dispute before granting probate. Can the executor be held personally liable for any mistakes? The executor's role is to act in the best interests of the estate and beneficiaries. If they diligently fulfill their duties, they cannot be held personally liable for mistakes made in good faith. However, seeking professional advice can help minimize any risks. That's all for today. If you found this video helpful, don't forget to like, share and subscribe for more informative content.